Hello, my name is David Stein, and today's presentation is called Top 10 Things to Know About Commencing a New York Commercial Foreclosure. The first thing I'd like to look at is requiring that the borrower be an entity. Requiring that the borrower be an entity can greatly mitigate potential issues that might arise in a foreclosure proceeding. For example, an entity cannot raise the defense of civil usury. So criminal usury is actually at 24%, and civil usury in New York is at 16%. So by making sure that the borrower is an entity, you eliminate the possibility that the borrower might argue that there is civil usury. There have been cases where the lender, for whatever reason, didn't require the borrower to be an entity. And during the foreclosure proceeding, the defendant, who was an individual, raised the argument that the interest rate coupled with the points and the closing fees brought the actual interest on the loan over 16%, and that was civil usury, and the judge actually gave weight to these arguments. Another thing is that transferring the property to an entity reduces the odds that the defendant will argue that this is a loan that's a residential loan, and therefore it should be considered a residential foreclosure. As many of you are aware, a residential foreclosure is far more protracted than a commercial foreclosure, and it involves many more protections for the borrower. The use of assignments of leases and rents. Now, the use of assignments of leases and rents is a very powerful tool. By taking over the property's income stream, you both eliminate an incentive for the borrower to drag out the foreclosure because they're not making income during that time. And you also help preserve the equity in the property because interest accrues on the debt day by day, and by taking those funds from the rents, you help ensure that it doesn't erode equity in the property. Having a personal guarantor. Now, assuming the guarantor has other properties, having a personal guarantor is a very powerful tool, and it provides leverage in a foreclosure for a lender to ensure that the borrower has incentive to work with them. While in residential foreclosures, banks seldom pursue the borrower for a deficiency. It's far more commonplace to pursue a defendant for a deficiency in commercial foreclosures, and borrowers realize this. And because of this, their attitude is very different, and they have an incentive to work with the lender. Forbearance agreements. Now, the use of a forbearance agreement can be very advantageous for the lender on many occasions. A forbearance agreement typically will give the borrower a concession in exchange for waiving defenses to the action. Now, using a forbearance agreement will be very helpful as it gives the borrowers an incentive to come to some sort of workout. It gives them breathing room to come to some sort of plan how to get out of the default. And it's a great way to work with the borrower on reaching a resolution. And the fact that the defendant has waived defense to the action, that by itself justifies using a forbearance agreement. Lending on an owner-occupied property. Lending on a property where one of the sponsors or members of the entity live in the property adds a layer of risk to that loan. A court may deem the loan to be a residential foreclosure in the instance where the borrower lives in the property, in which case, as mentioned earlier, there is far more protections for the borrower, and the foreclosure is going to be far more protracted, and it will be a greater headache for the lender. Furthermore, there's certain restrictions surrounding a non-licensed lender lending to an individual, which the borrower might raise in the foreclosure. So these are all things you should be aware of. Transfer of the deed. Now, there are times, for whatever reason, that a lender will decide that instead of using typical loan documents, such as a mortgage or a note, they will instead hold the deed in escrow and make the transaction look like an actual sale. And there are various reasons why they do this, but this comes at a great risk because most judges will consider such a transaction not to be an actual sale, but they will consider it to be a loan in disguise, and they will require the lender to actually go through with regular foreclosure proceedings, and the lender will be left at a disadvantage because they'll have to foreclose, and at the same time, they're left without the protections in place that would be included in a typical mortgage document. The statute of limitations. Now, it's very important to pay attention to the statute of limitations. The deadlines when commencing a foreclosure. Courts are typically very strict in enforcing statute of limitations deadlines. So even though they might be more favorable to a lender in a commercial foreclosure, they still will be very strict in enforcing those deadlines. It's important to timely prosecute a foreclosure action. Now, while judges might be less sympathetic to a borrower in a commercial foreclosure, they will give a lot of weight to a defense raised by a borrower that a foreclosure was unnecessarily delayed. And many times they'll also decide to waive interest if they decide that the foreclosure was unnecessarily delayed. So making sure that the proceeding goes forth on a timely basis is something that's very important. Paying insurance and taxes. Many of you know this, but it's important to take care of these things. You want to preserve the value of the property. This way, when the property goes up for auction, you are likely to recover most or hopefully all of the money that you are owed. And of course, it's important to retain experienced counsel. You know, look for counsel that has experience in commercial foreclosures, and preferably someone that has experience in that specific county where the foreclosure is being commenced, because they'll be aware of what specific judges in that county pay attention to. And feel free to reach out to me and my office if you have any further questions. And I hope you found this presentation helpful.